of the places that actually do those exams. So there is still a discrepancy, is my point. So we need to address that. And so House Bill 2228, Section 1 will require law enforcement agencies to adopt a policy that will require them to submit the sexual assault kits that are associated with a reported crime to one of the 3 laboratories within 30 days. 30 business days. We tried to give them a little bit of leeway on how much time they had to submit these. We know that there's resource constraints and everything else, and so we wanted 30 days. Another important piece to that is that those investigating officers that are working those cases make sure that we get those results from the testing back to those officers. That's going to be your key link in getting that eventual suspect identified, or the eventual leads to go up and start working further on that case. The second recommendation that came out was the recommendation to test all kits. So if you look at the topic of serial offenders, when we talk about sexual assault, many serial offenders, well, actually about 63% of all known rapists have committed more than just one rape. And of that, approximately for every one rapist, or the number of rapes committed each year by serial offenders, I'm sorry, that's a better way to say that, there's approximately 7 sexual assaults committed each year by serial offenders. And finally, I wanted to tell you that for every serial offender that's out there, they typically will offend 49 times before they reach their first conviction. So serial offenders are a very significant issue. And one of the things that helps to identify those serial offenders is CODIS, the Combined DNA Indexing System. When an individual is assaulted or evidence is collected, it's sent into the lab. The lab identifies a DNA. If it's an unknown DNA from the victim of the case, then that DNA is uploaded into the CODIS system. That CODIS system is looking at all known offenders as well as any other cases that might have been collected, or DNA that might have been collected from other crime scenes. If a match occurs, then the process starts of identifying or notifying the people who were involved in those matches, and then we start looking at identifying that offender. Oftentimes, this is how our serial offenders are identified. And so it's imperative to get those kits into the lab and get those DNA efforts or profiles uploaded into CODIS so that we can identify those serial offenders. So Section 3 of House Bill 2228 will require all laboratories to process and examine all sexual assault kits that are related to a report of sexual assault to law enforcement. One additional recommendation that came out of the Saki group is the need to retain evidence that is associated with unreported sexual assault kits. So when a person has been assaulted, they go to a hospital, they have their option of whether or not they want to report this to law enforcement or not. If they choose not to report it, then it becomes an unreported sexual assault kit. The hospital or facility will still take the evidence. They will collect that, and then they will send that to the KBI in an anonymous format. That kit is retained by the KBI. It is not tested, but it is retained by the KBI for 5 years. Per statute, at the end of 5 years, we have to destroy that kit. I believe that when the statute was created, or when we started looking at anonymous kits, the statute of limitations was 5 years for most sexual assault crimes. Unfortunately, since then, in 2013, Kansas eliminated the statute of limitation for rape, and it extended the statute of limitations beyond 5 years for many of the other sexual assaults, sexual offenses. So if you look at the national best practices when it comes to sexual assault kits, according to the National Institute of Justice and the Federal Survivors Victims Bill of Rights, They both indicate that you should be keeping unreported sexual assault kits for a minimum of either 20 years or until the statute of limitations expires, the lesser of the two times. Since we do not have a statute of limitations in Kansas for the crime of rape, the KBI supports the idea of extending our retention of unreported sexual assault kits from 5 years to 20 years. We did provide a very a minor fiscal note in respect to this. I want to make you aware of that. You should have that. But we believe that retaining these kits for 20 years is in the best interest of the survivors and the best interest for criminal justice. Finally, the last piece of 2228 that I'd like to discuss is the child advocacy centers. There are several places in the state of Kansas that victims have to or survivors have to travel quite a good significant distances to get services for sexual assault exams and sexual assault services in general. So we recommend that many of these benefits and services are available through child advocacy centers in communities throughout the state. By amending 65-448 and allowing evidence collection to be done at child advocacy centers, in addition to medical facilities, we would recommend that it would provide greater access and availability to survivors of sexual abuse and assault, and would be a better just environment in many situations for collecting these types of evidence from children specifically. I do want to note that when we were writing this bill or the draft, we actually determined afterwards inadvertently that through the type of language we were using, we had recommended that evidence collection be done in child advocacy centers and medical facilities that are licensed. This would preclude, unfortunately, locations that have licensed medical staff that could do this evidence collection and exams, but are not necessarily in a licensed facility. So we recommend an amendment to the bill that would include the ability for licensed medical personnel as well as licensed facilities to be able to collect sexual assault evidence and to do these sexual assault exams. Finally, I just want to end by discussing a recent case. Unfortunately, only last month, the Wichita Eagle reported a lawsuit that was filed in federal court that related to a rape of a person in a nursing home. And unfortunately, there was a delay in getting that sexual assault kit to the laboratory. Once we did get that, we did the analysis, and according to the Wichita Eagle, there was genetic evidence of the subject found in the sexual assault kit. My point in all of this is that these cases are still occurring. Unfortunately, we need to get these kits to the laboratory. We need to get them tested. We need to identify these subjects. And I would just ask for your support in the passage of House Bill 2228. I thank you for your time and consideration, and I would be happy to stand for questions at the appropriate time.
Thank you. Representative Carmichael with a question.
Thank you, Mr. Chairman. Mr. Roberts, I appreciate you being here today. The example that you just gave about the old rape kit that led to a prosecution of a nursing home molester makes me wonder, why in the world did Kansas law enforcement allow 2,000 or more rape kits to go untested for years while rapists roam the streets?
Well, thank you, Mr. Representative Carmichael. Just to clarify, the case that I gave, I don't think it's been adjudicated yet. It was a lawsuit that was filed in it. I think it's still in process in the nursing home.
Okay, you brought it up. I didn't. I'm sorry.
No, you're fine. I just wanted to clarify that. I wanted to make sure there was no misunderstanding. But to answer your question, I believe that when the Saki committee looked at many of the reasons why sexual assault kits were not submitted to the laboratory, there were several. There was resources, there was training, there was a general view of how sexual assault cases should be handled and the response to sexual assault cases. So it was there were some issues and some problems identified. There was some measures taken to try and fix some of those things through training with law enforcement. That training still continues, and but I can't give you a reason as to why law enforcement unfortunately didn't do this, but I can tell you that there are efforts being done to correct it.
And by the way, I apologize for calling you Roberts. I know your name is Jacobs. I apologize. Really, that answer is of little comfort to the victims of sexual assault who've gone years with cases not being processed and with their attackers roaming the street. But let me then ask a different question. Why does it take a law to force Kansas law enforcement to do its duty and test these rape kits? Why don't you just go ahead and take care of it?
Well, my understanding of this, and I'll be honest to tell you that I kind of came into this halfway through the process, but my understanding is that once these kits were identified and the KBI requested that law enforcement all start sending these in, that the adherence to that greatly rose, and there is and those kits are being sent in now. This measure of trying to suggest or draft House Bill 2228 is just a way to fix or to close the gap in the law. We really want to try and prevent those kits being kept by law enforcement. There are I can't even tell you the reasons why it's being done, but this would kind of prohibit the ability for them to hold on to them. I honestly don't know those reasons, but this would prohibit that.
Well, we could go on, but it's just appalling to me. The Kansas law enforcement allowed this situation to go on for years and years and years. And it wasn't until advocates came to us that law enforcement got off its butt. But even now, we have to pass a law to make them do their duty, and it's appalling. Thank you.
Further questions for this conferee? Do not see any. We'll move on to Michelle McCormick.
Good afternoon, Chairman Patton and members of the committee. My name is Michelle McCormick. I'm the Director of Victim Services for the Kansas Attorney General's Office. And on behalf of Attorney General Schmidt, I'm here to ask for your support for House Bill 2228. Our office, we participated as a partner in the Saki project that was well described by Mr. Jacobs. And we really, a lot of good work came out of that project, although it was unfortunate that the project was needed. And so we especially are proud that the backlog was virtually eliminated, but also there are some important lessons learned that came out of that, including, the Saki project guided the criminal justice system in understanding the value of testing all of the kits. And so we do think it's important to have this bill passed so that those linkages in those cases can be made and that we can identify serial offenders, because that will not only have an impact on the victims who were perpetrated against, but also go a long way towards preventing sexual violence. And so our office will continue to work with what's now the Kansas Sexual Assault Response Advisory Council, which is a multidisciplinary group. It includes law enforcement, it includes county and district attorneys' offices, victim advocates, lab professionals, and medical professionals, all coming together in order to help shape these model policies and model practices. And these are the folks who bring this bill to you today. We're working together in order to get improvement on these initiatives. And so I will keep my remarks brief because you have my written testimony, but essentially wanted to bring to you today the encouragement of the Attorney General's office in order to pass House Bill 2228. And so with that, I'll stand for your questions.
Thank you, Michelle. First question is Representative Carmichael.
Thank you, Mr. Chairman. Appreciate you being here today. When I read this bill, I didn't note that there were any enforcement provisions. We have a bad record of Kansas law enforcement not paying attention to rape kits and frankly not pursuing these cases. And I appreciate Mr. Jacobs' explanations. I bet I could fill in the blanks as to why some weren't being tested. But given the fact that we had to go to the trouble to pass a law to make Kansas law enforcement do its job, why don't we have any enforcement in this bill? In other words, if the chief doesn't turn in the kits, then they go see the C-post for dereliction of duty. Why aren't we doing that?
I think that our agreement in the sort of compromised work that we were doing, the collaborative work we were doing in the group, was to really emphasize passing the policy work so that we could start there in order to make sure that everyone's on the same page about having these policies. And then, of course, as Mr. Jacobs mentioned, the training will continue so that we can address those reasons that might have contributed to that.
Thank you, Mr. Chairman.
Any further questions? Seeing none, we will move on. Next, we have Representative Coleman.
Thank you, Mr. Chairman and members of the committee. Can you hear me all right?
Yes.
All right. So as the distinguished previous conferee noted, about 300 test kits go untested in Kansas. At one point, we had 2,200 kits not tested. If a person goes through the trouble to report a sexual assault and undergo a kit, that kit should be tested. From my research, a sexual kit takes 4 hours to complete and up to 10 hours total, including waiting time to receive said kit. This time burden alone, including re-traumatization done onto survivors by having to retell their story to nurses and detectives, is already a disincentive to report a sexual assault. Victims are re-traumatized only for the kit not to be tested. In 2020, due to COVID, fewer people stepped forward and reported sexual assaults, leading to a test kit being performed. People feel unsafe to go to a hospital. Sadly, while the number of kits performed has decreased, we know the number of sexual assaults hasn't. When we live in a time when people already struggle to report sexual assaults, do they need more reasons to not report it? If DNA is tested, it is entered into a national database, CODIS, and repeat offenders can be tracked down if their DNA is found on multiple victims or if found on the same victim more than once. One research study in the SAGE journal suggests more than 87% of alcohol-involved sexual assaults was committed by serial perpetrators. If testing can save even one would-be victim from a serial perpetrator, then this bill would be a success. I urge the members of the committee to protect some of the most vulnerable and defenseless in our society by voting yes on HB 2228 and making sure victims receive the justice they deserve in a timely manner before another serial perpetrator reoffends before the first kit is ever even tested. Thank you for your attention, and I will stand for your questions at the appropriate time.
Questions committee? Do not see any. Next, we'll move on to Julianne Walker.
Good afternoon. Thank you, Chairman Sutton and the members of the committee for allowing me to be here today and talk with you a little bit about our support for House Bill 2228. I am Julianne Walker. I'm the Executive Director for the Children's Advocacy Centers of Kansas. We are the state chapter association that is associated with the membership of 16 nationally accredited child advocacy centers across our state. And then we also have an additional 17th center being newly established as we speak. Child Advocacy Center that we work with, they are a child-friendly, neutral location for children and families to be able to come and receive services following a report of abuse. Children's advocacy centers are proponents of making sure that investigations are coordinated in a joint way. We conduct child forensic interviews. We provide advocacy and victim services, and also create access to medical and mental health referrals and services. So our support for this bill comes in really making sure that not only are these medical examinations accessible to children following the report of abuse, but also making sure that these kits are being sent to the appropriate laboratory so that they can be tested. In child abuse cases where evidence is collected, it is critical for them to be able to know that there is a process for them beyond just receiving that initial treatment during this time. And then by adding children's advocacy centers as an intentional location for these examinations to take place, it increases the opportunity for families to have additional options. Sometimes barriers are created around transportation. If you have access to that family and that child at that moment, sometimes it's better to go ahead and do the examination than have them go across the city or even to another county to a provider to be able to have those medical services. And so our intention with this is to be able to have specially trained medical providers available, sexual assault nurse examiners, and other medical professionals that have the training to be able to do this. If they can access it on site, then that's a service that we would like to see created. So just again, we would like to thank you for the support for this bill, and I will stand for questions.
Questions? Not seeing any. We will move on to Morgan Stebbins. If Morgan's here, I don't know that I see her on the list. So we will treat that testimony as written, so make sure to review that committee. Next is Greg Smith.
Thank you, Mr. Chairman. Greg Smith, Special Deputy for Government Affairs for the Johnson County Sheriff's Department. And on behalf of Sheriff Calvin Hayden, we are in support of this bill. The one request we have is an amendment to the bill, more technical in nature than anything else. Our crime lab is referred to in the bill as the Johnson County Criminalistics Laboratory, and that is an incorrect name. It is actually the Johnson County Sheriff's Office Criminalistic Laboratory, and we would just ask that that change be made. I believe this language only appears in two places, page 1, lines 9 and 10, and page 4, lines 16 and 17. And as with the other proponents, happy to stand for questions at the appropriate time.
Representative Ralph with a question.
Thank you, Mr. Chair. I just wanted to take a moment to offer my apologies to Special Deputy Greg Smith and the other representatives of law enforcement on this call and in this hearing. Appreciate the fact that this is some good work being done in this matter, but the previous comments disparaging Kansas law enforcement, suggesting that our public servants are sitting around on their butts rather than addressing certain situations or actions that need to be taken. And we all certainly believe that additional attention needs to be submitted to those. But I just wanted to tell you that those particular comments don't represent the majority of persons on this particular call or in this hearing, or specifically from myself. And I just wanted to let you know that that's not the thought in any form or fashion. And we appreciate all of your efforts in these regards, particularly in reference to this particular matter. So, and that's all I've got, Mr. Chairman. Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Well, obviously the vice chair and I disagree, but that's not important. Mr. Smith, why has there been years of delay and thousands of kits that haven't been examined?
Representative Carmichael, Chairman Patton, the other proponents have discussed that situation. I really don't have much to add to it.
Well, in my judgment, whether the vice chair agrees or not, it's an intolerable situation and it's an embarrassment. Thank you.
Any further questions? Not. Next up is Kathy Ray.
Good afternoon, Chairman Patton and members of the committee. My name is Kathy Ray, and I'm the Director of the Advocacy, Education, and Rural Projects Division for the Kansas Coalition Against Sexual and Domestic Violence, or KCSDV. Many of you probably know KCSDV is a statewide coalition of private nonprofit sexual assault and domestic violence victim advocacy organizations that provide direct services to victims, survivors, and their families across Kansas. Thank you for allowing me to speak today and show our support for House Bill 2228. So I had the privilege of working collaboratively with the KBI on this Sexual Assault Kit Initiative, or the SAKI project, and now I have the privilege of co-chairing the Kansas Sexual Assault Response Advisory Committee. And these are truly multidisciplinary efforts that involve all stakeholders in the sexual assault response. So as you probably know, sexual assault and rape are very prevalent in our society. About 1 in 5 women and 1 in 71 men have experienced attempted or completed rape in their lifetime. And the majority of victims experience this before the age of 25, so pretty early in life. We feel like House Bill 2228 accomplishes some pretty critical improvements to Kansas's response to rape and sexual assault. And I'm going to just briefly summarize why we support this bill and why we feel it's a step in the right direction for Kansas. So the first piece this bill accomplishes is ensuring that all sexual assault kits that correspond to a law enforcement report of sexual assault are submitted to a forensic laboratory and are examined. So I don't think there's any mistaking the fact that sex offenders have a clear impact on public safety, as Mr. Jacobs pointed out. Of the 2,200 sexual assault kits that were analyzed as part of the SAKI project, 907 suspects had a trackable criminal history. Of those 907 suspects with a trackable criminal history, a total of 7,302 sexual and other violent offenses were identified in their criminal histories. And these offenses included everything from homicide and rape, indecent liberties with a minor, domestic violence, burglary, and assault on a law enforcement officer. Testing sexual assault exam evidence increases the likelihood of holding perpetrators accountable, increases the likelihood of identifying perpetrators, and can help prevent future sexual assaults from occurring by linking the perpetrator to other crimes. So I've been working in this field for almost 20 years. I've had the opportunity to work directly with many victims of rape and sexual assault. I've sat with victims of rape at hospital emergency departments while they underwent a sexual assault exam. And some of you may be familiar with this process. I think it's been pointed out that these are typically performed by a trained nurse or a sexual assault nurse examiner, often called a SAID. But it's a very uncomfortable and invasive process where the victim receives medical care while evidence of the sexual assault is collected from truly the most intimate parts of one's body. This here is the Kbi Sexual Assault Kit, where the evidence is packaged, and it includes about 15 steps as part of the collection process, and it's usually about a 4 to 6 hour process to complete. So sexual assault and rape are also of the most underreported crimes in our society. And consistent with that, the majority of victims I've worked with did not make a report to law enforcement at the time of the assault. Studies show that of 1,000 rapes that occur, about 250 are reported to law enforcement, so about 25%. And delayed reporting of sexual assault is also pretty common. There are a wide range of reasons why people don't report. Oftentimes, they even hide it from their friends and family members. The majority of rapes are committed by someone known to the victim. About 80% of rapes in Kansas, the offender is known to the victim in some way. So self-blame, self-doubt, those are not uncommon, as are feelings of shame, guilt, and embarrassment. We live in a society where the victim is often blamed for their own rape. where they were, who they were with, what they were wearing, what they were doing or not doing. Victims hear these messages, and it definitely plays into whether they are going to report this to law enforcement or not. And finally, fear of not being believed is among the strongest deterrent of not reporting rape. So for those victims I worked with who did report to law enforcement, they reported the crime and underwent the sexual assault evidence collection process under good faith that a thorough investigation would be conducted. They were told that the evidence collected could be used for the criminal investigation or prosecution. They're told this as part of the exam process. When they later find out that the case won't proceed because the suspect claimed it was consensual, this is so common that we actually have a name for this. It's the consent defense, and it's really to be expected in almost every rape case, or because there's a lack of evidence. And then they later find out that the sexual assault kit was never even submitted to a lab for testing. The discouragement of victims reporting these crimes continues. For some victims, testing these kits sends a message that you do matter, your case matters, and what happened to you matters. Processing and analyzing evidence are a part of any thorough and complete investigation for almost any other crime, yet with rape, that has not been the case. It's time for systems to take sexual assault and rape seriously, to believe victims, to prioritize testing of sexual assault kits, to understand the value of uploading suspect DNA profiles into CODIS. It's time for systems to protect victims and to hold offenders accountable. We also support this bill because it expands access to sexual assault exams for victims. So KCSDV, we help coordinate the SANEs across the state, and we also provide medical professionals with the specialized trainings that they need to perform sexual assault exams and evidence collection. As Mr. Jacobs pointed out, SANE programs are pretty scarce in Kansas. Only 21 counties of Kansas's 105 counties have a SANE program. Most operate at very limited capacity. So it's not uncommon for victims to have to travel several hours to receive the exam, or to simply be turned away because no one at their local emergency department is trained to perform it. These victims never receive the medical care and services they need, and the evidence of the crime is lost. Access to sexual assault exams must be expanded, and by increasing access to exams, we are also increasing access to services and support. Child advocacy centers, doctors' offices, clinics, and health departments are all appropriate facilities for these exams to take place when they are performed by the appropriately trained medical professionals that are detailed in the current law. And we feel like House Bill 2228 makes this clear. And finally, we support the retention of unreported sexual assault kits by the KBI from 5 to 20 years. As Mr. Jacobs pointed out, this is consistent with national best practices. The statute of limitations for rape was eliminated in 2013. So should a victim report the rape beyond 5 years post-assault, the evidence would no longer be available for the investigating agency or for prosecution. So by increasing the retention of unreported sexual assault kits, we are providing victims sufficient time to consider whether to report to law enforcement, and are providing law enforcement and prosecutors the tools they need to improve those criminal justice outcomes. So in closing, I just want to say, while we're talking about sexual assault kits, while we are talking about sexual assault exams, I want to remind us all that these kits are not merely numbers. Behind every single one of these kits is a person. This person is a loved one. They're a family member, they're a friend, they're a coworker, and they're members of our communities. With that, I would like to strongly encourage you to support the passage of House Bill 2228, and doing so shows your support for victims and survivors. Thank you for letting me speak this afternoon, and I'm happy to take any questions you may have.
Representative Carmichael.
Thank you, Mr. Chairman. Ms. Ray, I very much appreciate you bringing your perspective to the committee. And in view of the fact that this bill does not have any enforcement provisions, and in view of the bad record that we've had for years in this state, I wonder if you could tell us, based on your 20 years of experience, what reasons or excuses or explanations were provided to victims of sexual assault as to why it was, after they'd gone through the trauma of reporting and having the kit done, why it is that Kansas law enforcement left it in a storeroom? What do you know about why that happened? Because we don't ever want it to happen again.
Well, as part of the Sexual Assault Kit initiative, there was actually a sample of kits that were analyzed from some pilot communities and a survey that went out with those kits. That is available on the KBI's SAKI website. So the findings from that survey, it basically asked why these kits weren't submitted at the time of the assault. And the top reasons why they weren't submitted were, one of them was an uncooperative victim. So we hear this quite a bit, where a victim may report the crime initially, and then at some point throughout the process drops out of the criminal justice investigation for a multitude of reasons. Another reason was the consent defense. So the suspect claimed consent, and you know, with the advances in DNA, it's almost so prior to DNA technologies, the defense was nothing happened, and now that's not an option. So the defense is consent. And I think that has to do with the lack of understanding of the value of the DNA profiles then being uploaded into CODIS to identify the serial sex offenders and violent offenders. So many people really aren't aware of that. And then another top reason was the prosecution declined. So at some point, whether it's the consent defense or drugs or alcohol were involved to facilitate the rape, the prosecution declined to take this case further. And, you know, through a lot of training and policy efforts, we have the investigation is not complete until the kit's been tested, right? So this is, we feel like, a step in the right direction. I think we're chipping away at a long history of what we call rape culture and disbelief of victims. The backlog of untested sexual assault kits didn't just exist in Kansas, it existed all over the country. And so many other states, as well as Kansas, are trying to take steps in the right direction to improve our response.
So were county and district attorneys in Kansas declining prosecution without even processing the evidence in the rape kits?
I don't know the answer to that. That was one of the factors. Now, this was a law enforcement survey. So for whatever reason, law enforcement identified that because prosecution declined. I do not know at which step that would be in the process.
Well, I appreciate the work of your organization and tens, if not hundreds of others to finally get this on the front burner. Appreciate it very much. Thank you.
Thank you so much.
Our next conferee is Victoria Pickering.
Thank you so much. I just want to start by saying thank you to Chairman Patton and other members of the Judiciary Committee. My name is Victoria Pickering. I'm the Director of Advocacy at the Metropolitan Organization to Counter Sexual Assault, commonly known as MOCSA. We are the Rape Crisis Center that serves survivors in the Kansas City metropolitan area, which it would include Johnson and Wyandotte counties in Kansas. We provide a variety of services to survivors, and I'll talk a little bit about what my department does. I also am coming to speak to you on behalf of my organization and behalf of myself in support of House Bill 2228. After working in this field for about 17 years, I actually started as a hospital advocacy volunteer and crisis line volunteer when I was a college student many, many moons ago, and took it upon myself to be trained and respond to the hospital when sexual assault survivors were going to have these types of exams done. So this is a topic that is very near and dear to my heart, and I'm just thrilled to be able to speak on behalf of this bill. So in my current role at MOXA and throughout my career as an advocate, I have been just absolutely honored to be able to sit with survivors during the experiences that they have after they have gone through such trauma. And oftentimes, the moments when I am first connected with the survivor is at their bedside when they go to an emergency room for a sexual assault exam. At MOXA, we respond to every local hospital that provides these types of exams, and there are more than 30 of them in the Kansas City area. So anytime a survivor goes to an emergency room in our region for a sexual assault exam, a MOXA advocate is automatically dispatched to the hospital 24 hours a day, 365 days a year. And in those moments when we respond, we are really there to provide any type of support that a survivor needs in those moments. So for me, I looked back through some of my records before coming here to testify today, and I can say that I have sat with hundreds of victims who have experienced these types of exams. So when we talk about the word kit, and that's the word we use in my field of work and in the criminal justice system, and when we evaluate legislation like this, we refer to it as a kit. And as Kathy showed us, that's a box, full of swabs and other items. But that term kit, I don't think really fully represents what happens inside those hospital rooms, what a survivor is choosing to do with their time after they've already experienced an assault. They're choosing to go and have to disclose a really horrific thing that was done to them, to not one person or two people, but to many people inside the hospital, to the person at the front desk at the ER, to the person who takes their blood pressure, to the sexual assault nurse examiner, to the advocate like myself, to the law enforcement officer who comes to take the report if the survivor chooses to report. That in and of itself takes an incredible amount of strength and vulnerability and courage and resilience for a survivor to do, when for many survivors, what they want to do in that moment is to go home and go to bed, or to call their best friend, go see their mom. And so they have set those things aside to go to the hospital. When they're at the hospital, one of the things that I tell advocates when I train them is every survivor is going to feel very differently in that moment, but ultimately some of the things that are connected across all sexual assault exams that I've been a part of is that the sexual assault survivor is having to direct the evidence collection of the crime that was done to them. So we've all seen the TV shows where a robbery takes place, or other types of crimes, and there's crime scene investigators who go out and they take pictures and use alternative light sources to look for evidence of that crime. And rarely in those moments do we see a victim of the crime actually having to tell them where to collect the evidence. And I think that's something that's so unique to the sexual assault exam, is that it's the survivor themselves who is having to consent to have their body treated as a crime scene. They're having to instruct in sometimes a very detailed manner the examiner on how to and where to collect the evidence based on what happened to them. So through this process, as we talk about that term kit and what it means to submit a kit to the lab and make sure that all kits are tested, we really want to make sure that we are recognizing what is represented by that box. It is a sacrifice that's made by survivors, and in doing so, survivors are putting their faith in the criminal justice system to take what happened to them seriously. So when a survivor has a sexual assault exam and also chooses to report that crime to law enforcement, we want to make sure that if nothing else, we can remove the concern that they may have that this box will go and sit on a shelf. And that's what this bill does. It allows us to take away that one worry. So we can't remove the worry that survivors have about their safety. We know that they worry about how they're going to talk to their friends and family about what happened. They might be worried about what it's going to feel like if they have to go to court, or if they need an order of protection. But the worry about whether or not this evidence will ever even see the light of day, whether it'll ever get tested, we have the opportunity as a state to remove that worry from survivors. And I think that's just such an incredible thing that we can do. This bill doesn't guarantee prosecution. It does not guarantee justice for every survivor. But it does allow us to say in those hospital rooms, in those moments with survivors, we can look at them and with confidence say, if you choose to have this done and law enforcement, this evidence is going to go to the lab and it's going to be tested. And that is, I think, really the minimum that we owe to survivors when they put their faith in us to help them heal. And with that, I urge you to vote in favor of passage of House Bill 2228, and I am open to any questions.
Questions, committee? Okay, committee, you also have written proponent testimony from the Johnson County Sheriff's Office Criminalistics Laboratory, Wichita Area Sexual Assault Center, and the Kansas County and District Attorneys Association. Is there anyone else online that is a proponent? Okay, is there anyone who is a neutral, wants to be a neutral conferee? What about an opponent? Seeing any of those. So going to close the hearing on House Bill 2228. Thank you all for coming today. We will now move on and open the hearing on House Bill 2299. And we will have Natalie give us a brief overview.
Thank you, Mr. Chairman. House Bill 2299 extends the time within which a search warrant may be executed. Current law in KSA 22-2506 requires a search warrant to be executed within 96 hours from the time of issuance. This bill would allow those search warrants to be executed within 10 days from the date it is issued. And I can take any questions.
Any questions for Natalie? Not seeing any. So we will begin with our first conferee, Representative Resman.
Thank you. Can you hear me?
Yes, sir.
Oh, good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to submit testimony in support of House Bill 2299 that will extend the time in which a search warrant must be served from the current 96 hours to 10 days. The intent of the bill is not only meant to ensure the safety of law enforcement officers, but also the public. During my career in law enforcement, which was more than half of it was spent in investigations, I was a member of the Metro Squad from Kansas City. And that gave me the opportunity to firsthand see how Missouri handled their search warrants compared to the way we handle them here in Kansas. And the amount of time, they're one of the states that allow 10 days to execute their search warrant. And it's really important to extend the time that law enforcement has in order to ensure that the search warrant's executed safely. I can tell you firsthand that people will protect their homes at all costs, just as they would a burglar. They'll defend it against law enforcement. Here in Kansas, and I can only speak for myself and the department I worked for 30 years, we would have to pre-plan everything we were going to do prior to receiving a search warrant. And we would have to hope that things would maintain constant or that everything went according to our plan. In Missouri, they can go ahead and plan, they can get the search warrant, and they still have 10 days to adjust their plan to how they're going to execute the search warrant. The department I worked for, we would always do our homework as far as trying to identify everyone that lived in a residence if we were going to execute a search warrant. We would contact utility companies, postal inspectors, we conduct drive-bys, all in an effort to identify people that might be affected by the search warrant. One of our special concerns is that there are children all sometimes involved, along with dogs, which, believe it or not, can be a major problem executing a search warrant. But all of this takes time, and if you do this before you obtain a search warrant, things can change, and being under 96 hours to execute a search warrant kind of puts you in a time restraint. I know recently in the news, we've heard in different parts of the country, there were several incidents in which the death of a law enforcement officer occurred, or a person in which was directly or indirectly involved in a search warrant. one I can think of most occurred in Louisville, Kentucky, where a young woman was killed, and that search warrant was
Representative. Okay, well, we'll hopefully pick back up with him in a minute. We're going to move on to Ed Klump.
Thanks, Mr. Chairman. Ed Klump. I am here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, the Kansas Peace Officers Association. We are in support of House Bill 2299. We would encourage you to move this bill forward. We did some research on this, and in the research we were able to do, we weren't able to see every state's search warrant criteria on service time. But the ones that we did found, we only found one state that had a 96-hour limitation besides Kansas, and that was Illinois. We only found 2 states that were under 10 days. Is enabled to save audio highlights. Mr. Chairman, you want me to go on, or you want to go back to Representative Resman?
Why don't you finish, Ed, and then we'll go back to Representative Resman. We can, Representative Resman. We temporarily went to Ed Klump. We're going to let Ed finish, and then we'll come back to you, okay?
okay.
Okay, thank you, Mr. Chairman. We also found 5 states that were over 10 days on their limitations. They range from 14 days to 60 days. We also looked at the border states around Kansas, Oklahoma, Missouri, Nebraska, Iowa have a 10-day limit. Colorado has a 14-day limit. I also went to the 10th Circuit and looked at all the 10th Circuit states. And again, they all have 10 days with the exception of Colorado and of course, Kansas. So we think it's reasonable. This is what most other states are doing. And we think the 10 days is a reasonable amount of time for us to have to serve the warrant. That additional time can be important because it will assist law enforcement by offering a broader time frame to serve the warrant and more time to consider safety concerns, timing of the service of the warrant, where it'll be the safest time to do it. It'll be safer for the officers, for the occupants of the place being sought, and for the subjects of the warrant. It'll also give us more time to plan the best opportunity to recover items being searched for. So in summary, it gives us more planning time, gives us more time for changing factors surrounding the service, and more time for surveillance of the place that subject to the warrant, and hopefully a time when we can have a better tactical advantage to minimize the need to use force. And we would recommend that we move the bill forward. And I'll stand for questions when it's appropriate.
Thank you. Representative Resman, if you're there, let's go back to you. And committee, let's do all 3 proponents, and then we'll do questions since we're kind of bouncing back and forth. Representative, do you happen to be there? Okay, we're going to move on to Greg Smith, and then we'll get back to the representative if he can make connection.
Thank you, Mr. Chairman. Again, I'm Greg Smith, Special Deputy for Government Affairs for the Johnson County Sheriff's Office. Chairman Patton, first thing I want to do is apologize. I noticed in my testimony I left one of the T's of your last name out. I do know how to spell your last name. I would echo what Representative Resman was saying, and also what Chief Klump was talking about. Being able to plan and safely execute a search warrant is paramount, and 96 hours is just not enough time to do that. We're particularly concerned if there are children on the premises, and we look for ways that we can facilitate a search warrant without having to have children there or other persons that may not even be a focus of an investigation. In our research, we looked at the states surrounding Kansas. Every state, Colorado, Missouri, Nebraska, Oklahoma, all does at least 10 days. Colorado does 14 days for a search warrant rather than 96. So we're clearly the anomaly here and not the norm. We would ask you to support 2299 again for the safety reasons that have been spoken about by the other proponents, and I'd be happy to stand for questions at any time.
Very good, thank you. Representative Resman, are you out there? Does not look. Yeah, now I'm destroying the technology in the committee room. Okay, well, we have his written testimony, and if he would like, we'll allow him to pop his head in someday when we're actually all here and finish his remarks. I keep seeing him on the screen, but then we lose him. So, committee, we also have written proponent testimony from the league. Anyone else as a proponent? Okay, let's do questions. Questions for any of the conferees? I don't see any. So what about, is there anyone who is a neutral conferee? Anyone who's an opponent? Not seeing any. We'll close the hearing on 2299. Open the hearing on House Bill 2363 and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2363 authorizes appointed counsel rate paid by the Board of Indigence Defense Services to be higher than $80 per hour. Current law in KSA 224507 provides that appointed counsel shall be compensated at the rate of $80 per hour unless the chief judge in the judicial district negotiates a lower rate or a contract between the Board of Indigence Defense Services and appointed counsel specifies a lower rate. This bill would allow those appointed attorneys to be paid at a rate that is higher than $80, and it would keep the existing exceptions that are in place right now. And I can take any questions.
Questions for Natalie? Do not see any. Thank you, Natalie. Our first and only proponent to testify here today is Heather Cessna. She's become a regular here.
I have been. Thank you, Mr. Chairman and members of the committee for allowing me a few minutes here to address the committee on this issue. Obviously, I was here just a week or so ago to talk about the issues that the Board of Indigent Defense is facing right now, and one of those has been being able to keep sufficient numbers of qualified counsel on our appointments list. And one of the main reasons for that is a combination of the pressure of the number of cases that are being offloaded to those panels, but also because the low rate of pay. That $80 per hour that's in our current statute has been there since 2006, and it is about 64% below what the going market rate is for current private counsel. What we were trying to do with this amendment was to amend the language in a way that would make it clear that $80 an hour would be a floor and not a ceiling, so that in the future, if the Board of Indigent Defense Services will have the opportunity to raise that rate up with some caveats. And one of the things I wanted to address briefly with the committee was just to let you all know that there are other there's other parts to this that sort of you may not realize just from looking at the language of this statutory amendment. Before a rate can be raised by the Board of Indigent Defense, the board would have to vote on that rate to raise. We would have to have sufficient allocation of budget money to be able to pay for that additional rate, and our rates are actually also set out specifically in our administrative regulations, and so that administrative regulation would also have to be changed every time we wanted to raise the rate, and would have to go through that entire process, which I know at least a couple members of this committee have also sat on that administrative regulations committee as well. So, so it's not as simple as if we make this a floor, not a ceiling, that all of a sudden the board can go wild and crazy with its rates. There's several other sort of components to the process that act as a check or balance, as it were. But this is an important step so that we have that opportunity, if we are to get funding at some point, to be able to raise that rate above $80 per hour. One of the other things I was going to point out to you, because they weren't available to testify today, is the proponent testimony that was submitted on behalf of KCDL. I think that Kate Zygtema went through and did a good job of sort of explaining all of the things that go into what that $80 per hour rate pays. It's not just a simple hourly rate. It actually goes towards paying the overhead costs of the various appointed counsel and what they need to be able to do in order to take these cases. And when you look at her layout that she provided, I think you can see that, very quickly that $80 an hour is just not enough to meet sort of realistic expectations of what a law office needs in order to be able to operate and take cases on a regular basis when they're taking these appointments. Other than that, I didn't have any other particular comments other than what we've submitted as our written testimony, but I'm happy to take any questions that the committee might have.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. I have not had a chance to read KCDL's testimony, so the answer may well be there. But how are lawyers or law firms, whatever, compensated for the use of legal assistance? Because we all know that oftentimes the work can be done by someone perhaps at a rate lower than an attorney, but still be able to provide excellent representation, as opposed to what insurance defense firms used to do, is bill the client for the lawyer doing everything from licking the postage stamp to running the photocopier machine. I'm being facetious, but how do you handle legal assistants, paralegals? How are they compensated?
That's a good question. Those are generally paid out of the $80 per hour rate as part of the overhead costs. Every once in a while, we do have a situation where a paralegal is hired, like sort of as an investigator on a specific case, and we handle those through our experts process, which is a whole different rate of pay, and that's done through contracts with those particular people.
So, for example, if I'm hired to defend someone on a relatively low-level felony case, which would be a mistake because I'm not competent to do that, but I would need to do all the work myself at the hourly rate, because if I used a legal assistant, whose rate would be lower, I don't get reimbursed for that at all. So I guess I'm just better off to do all the work myself at the higher rate than what a legal assistant would earn. Is that the way it works?
I mean, or you're paying it out of the overhead costs for, essentially the out of your cost of operating that comes out of that $80 an hour rate. So you're charging $80 an hour for your particular rate, and then whatever amount is sort of left over after you pay your other overhead costs, like your electricity and your Westlaw or whatever, that's where you find the money to pay those paralegals. So you're not paying them separately.
But that wouldn't make very good economic sense at all. If I can get paid for doing it myself and I don't get paid at all when somebody else does it, I think there's a strong financial incentive them not to use legal assistance. I mean, in my practice, we bill lawyers with law licenses at one rate, and we bill legal assistants at a lower rate, and we think that saves our clients money. But in the bid system, the way it works right now is either the lawyer does it and bills for it, or the lawyer eats the cost of the legal assistant because you don't get paid for those hours.
Yeah, traditionally, a lot of our appointed counsel are solo practitioners that don't have a lot of support staff. And like I said, there is the opportunity there occasionally, and it does happen occasionally, where we utilize those other, like I said, investigators or paralegals as part of our experts process, which is a different payment system. But yeah.
Okay, I appreciate the answer. Thank you, Mr. Chair.
Any other questions, committee? Don't see any. You also have written proponent testimony from the Kansas Association of Criminal Defense Lawyers and the Kansas Bar Association. Anyone else as a proponent? Anyone as a neutral? Anyone as an opponent? Okay, close the hearing on House Bill 2363. Committee, my understanding is Representative Resman can hear us now. Can you hear us?
Yes, well, I can't get my the camera to work.
That's fine. If you just want to finish your remarks, that would be great.
Okay, well, I think I kind of know where I left off. Just recently in the news in different parts of the country, there have been some deaths that occurred as a result of the execution of search warrants, and of officers and people that may have been directly or not directly involved in the search warrant. And the one that comes to mind is the one that occurred in Louisville, Kentucky, that occurred at night, in which if officers had additional time, they may have been able to just kind of outweight the occupants of the apartment, or which we have done on numerous occasions, is wait for one of them or both of them to leave and then conduct a traffic stop and then ask them to come back to the residence, where then you can control the situation a little bit better. I just think that if Kansas law enforcement officers were given additional time, like the counterparts in the surrounding states, they'd be able to better control the situation and not be pressured to execute a search warrant, and it may not be convenient for everybody's safety. So I think just extending the time would just make things a lot safer for everyone involved in the execution of a search warrant. And if anybody has any questions, I'll be happy to answer them.
Any questions? Representative Jennings.
Thanks, Mr. Chairman. Representative Resman, my suspicion is should we go to working this bill, that probably someone comes along and says, hey, while we're talking about search warrants, what about this no-knock business? And I think there's a bill pending in corrections and juvenile justice around that. In order to give folks an opportunity to hear a little bit about maybe your thoughts on that, can you share your thoughts about the notion of no-knock warrants?
Well, it's kind of like, it's just something that you're going to have in your duty belt, something that you may need sometime down the road, and to eliminate them probably would not be the wisest thing. But if we extend time out for the execution of a search warrant, the officer, like I said, the officers can outwait somebody, perhaps do it during the day and not at night, not have to knock, wait for people to leave, ensure that there's no kids or dogs, because they're always a problem too. But I kind of think that that allowing people to leave the residence, just kind of outweight them, just give us more time to come up with a plan.
Any further questions, committee? Thank you for your persistence at getting joined back with us, Representative. Committee, that's all we have for today. We do have 3 bill hearings for tomorrow. I am having Kathy, when they submit their testimony, encouraging them to participate via WebEx. It looks like it's going to be just as cold tomorrow, if not more than it is today, and we've got power issues, so I encourage you all to do what you did today and WebEx in. I will probably be here again just to make sure someone presses that green button, which I didn't do such a good job of today, but somehow gets this meeting started on time. So we'll make sure we're better at that tomorrow. Have the 3 bill hearings, but we will not be working any bills, so you do not have to be in the Capitol building. That's all I have. Everybody stay warm, and we'll see you tomorrow, probably online. Our meeting's adjourned. Thank you.